All right, this is case number 21-168-683. This is Portfolio Recovery Associates LLC versus Stacy Withers. That is before the court, set on for a hearing. This is after there's been an answer, but I don't see the answer to the problem. Let's see where things are. Your appearance for the plaintiff.
Good morning, Judge Coleman. Cezanne Barta, P65425 on behalf of the plaintiff.
Thank you, Mr. Barta. Good morning to you. For the defendant in this matter is Ms. Stacy Withers here, or someone representing Ms. Withers. All right, counsel. So I see the amended answer, and I guess that led me to believe that there was some
Amended complaint.
Yeah, led me to believe that there was some answer, but I don't see answer file. What's going on here, sir?
Your Honor, I don't even see service perfected in this matter. So I would ask Your Honor on his own initiative to dismiss this action for non-service.
All right. Thank you, counsel. I knew that you'd have an answer that was eluding me.
I would just ask that the dismissal would be without prejudice when you fill that out, please.
All right, the matter will be dismissed. It is dismissed without prejudice as it relates to a service matter.
Thank you, sir.
Thank you, counsel.
Have a good day.
And likewise to you, sir. The court now calls case number 21. Case number 21, 168087. This is here on home management versus City of Detroit. The matter is before the court, having been joined. I believe that this is a first hearing regarding this matter. Your appearance for the plaintiff on this case, please.
Your Honor, Michael Xavier on behalf of the plaintiff, which is here on case management, Your Honor.
All right, you said something at the end there. Mr. Xavier, let's have your P number, if you will.
P76438, Judge.
All right, you said something about the case number. What did you say, sir?
No, Judge, you read it into the record as here on home management. I just wanted to clarify it's here on case management.
Yeah, I don't know why I put home in there somewhere. I just dated that. All right, that's the file does reflect here on case management. Thank you, sir.
Yes.
All right. So have you spoken with somebody from the City of Detroit on this matter?
I haven't, Your Honor. They filed responsive pleadings, and this court sent out a notice of pretrial, and both parties are on it. But other than receiving responsive pleadings, no, I haven't gotten anything. We did file an objection to the demand for compulsory joinder because this is the correct court for this matter. But other than that, no.
All right. And that sounds like Mr. Hildner to not be here. So I'm wondering what may have happened. So what I'm going to do is, what do you need by way of discovery in this matter, or what do you think might? Do you think a 60-day calendar might work in this regard?
Yeah, Judge, I don't need much. As you could tell from my name, we're a case management company, so we have a substantial amount of medical records for the underlying claimant. So I personally wouldn't need a lot, just the claim file from the city or their third-party administrator. I don't know what the city wants or their reason for not paying the bill, so I'm not sure what they would require. 60 days is more than enough on my end of it.
All right, very well. So I'll go ahead and set it up on, or maybe I'll even set it on a 45-day calendar. So I'm going to give a return date. I'm going to open discovery throughout the period from now until that return date. I'll issue an order relative to discovery. The date of the return date is going to be
March 16th.
March 16th, 2021. I'm going to set it on at 9:30 a.m. I will issue an order allowing discovery to be open through that time In that order, it will also allow for the filing and setting of motions for hearing on that date, so long as the motion allows at least 10 days for the opposing party to respond. So you can file a motion dispositive or otherwise and set it on for hearing on the 16th of March at 9:30, so long as you get given 10 days notice to the opposing party. With regard to the motion for compulsory joinder, I'm going to take that motion under advisement, set it on for hearing on the 16th of March. We'll just renotice it and hear it at that time. And again, if any other motion is filed, it can be heard on that date as well. Just give 10 days notice to the other side.
Okay.
You'll get a copy of that scheduling order in the mail. I'll make sure that it's sent to Mr. Hiltner as well. All right.
Okay.
Thank you, counsel.
Thank you, Judge. Have a good rest of your day.
Likewise. All right, this is case number, Madam Dillo, I believe you're here on some of the default matters. Is that correct, ma'am?
Yes, Your Honor.
All right, I'll be right with you in just a moment.
Sure.
This is case number 21-241008. This is Aquicia Regans, R-E-G-I-N-S versus Rondo Investments. The matter is before the court, having been removed from the small claims division. A matter set on for a hearing on this matter on today's date. Your appearance, let me see if I have Ms. Regans on this Zoom. Ms. Regans, if you're on this Zoom, a person living on Greenfield Street, please say something at this time. For Rondo Investments, please.
Good morning, Your Honor. Attorney Donna Hutchison, P85117, appearing on behalf of plaintiff. I'm sorry, defendant.
Just for the record, if you will spell that last name, please.
Defendant, Hajhassan.
All right, thank you, Madam Counsel, and pronounce it for me one more time.
Hutchison,
That's Casson.
yeah.
Close enough.
Yeah, that's
Right. I got one of those simple ones like Coleman. So, all right, very well. So have you had occasion to speak with the other side on this? We're dealing with the Regans versus Rondo matter, and if anybody is coming in is on it, say something. You spoke with the plaintiff regarding this at all?
I have not, Your Honor. We did file an answer to the plaintiff's complaint, and we filed a counter complaint because she does have, or he or she, Aquicia, has an outstanding balance of unpaid rent.
All right, well, it looks like she has not appeared regarding this matter. The record should reflect that a notice did go out on the 15th of November, advising her of the requirements at this hearing, and in fact, establishing the meeting ID for this Zoom hearing. It looks like the plaintiff has not appeared regarding this matter. So I know that you have counterclaim this matter.
Correct. We were going to file a separate landlord tenant claim in this case, but since this plaintiff filed this case, we just put it as a counter complaint. There's an outstanding rent balance of actually now it's gone up to $4,913.92. But we do have a deposit of about $1,200 being held.
At this point, where the defendant has not appeared for this hearing, I'm going to simply dismiss the complaint in this matter. If you wish to proceed on the balance of this, I'm going to have you do that separately. Given that she hasn't appeared, I'm going to dismiss her complaint this time.
Would you like us to file a separate landlord tenant action on this? Can we deal with the?
I think under the circumstances, particularly with the dollar amount that you're setting for, that is probably a better way to do it.
Okay.
So that the complaint in this matter will be dismissed. This case is dismissed at this time.
Okay, thank you, Your Honor.
Thank you, Counsel. Good day to you.
You too. Bye.
Himmler. Good morning to you, sir. I called your matter previously and expressed the extreme shock that you were not there. I indicated to the other side on this that we would go ahead and set it on a 45-day schedule for with a return date for March 16, 2022. And I'll be issuing a written order in that regard. So go ahead and put your appearance on the record regarding suffix 8087.
Good morning, Your Honor. Philip Hiltner, P77913 for defendant.
All right, thank you, Counsel. Mr. Xavier, Michael Xavier was here, and I set a scheduling board as I indicated regarding this matter, and I took under advisement the motion for compulsory joinder that'll be heard on the 16th of March at 9:30, and any other motions that might be raised, as long as there is a 10-day notification to the other side, I will hear such motions on March 16, 2022. Anything you want to bring to my attention at this time? No.
Okay, understood, and thank you, Your Honor.
I thank you. Good day to you, sir.
Yes, good day to you as well.
Mr. Johnson, are you here on Genesis? Mr. Johnson, are you here on the Genesis case?
No, Your Honor, I'm not. I'm here on the security credit case.
That's a default type matter, correct?
Correct, Your Honor.
Okay, I'll be right with you. Ms. Dillon, do you have one matter or more than one, ma'am?
Your Honor, I have 4 matters.
Okay, let me see if I can get to your matters. Give me the last 4 digits on the ones that you have. The first one.
845.
Hold on one second. Got that one. Go ahead. Give me another one that you have.
859.
I have that one now. What else do you have?
747.
What was that one, please?
747.
I have that one and your last one.
843.
This is case number 21-160-845. This is Capital One Bank versus Keith Brooks Jr. The court is also at this time calling 21-160-859 Capital One Bank versus Laneda Whitlock. Court calls case number 21-161-747. That's Capital One Bank versus Ronnie Foster. The court calls case number 21-160-843. That is Capital One Bank versus Nicole Anderson. These matters are set before the court on today's date for a hearing on a motion for entry of default judgment. The court did receive the plaintiff's application with regard to each matter. The default was previously entered. The court set today's date as a date for the entry of the judgment, unless the defendant could show cause as to why the judgment should not be entered. In each of these matters, defendants did not previously respond to the complaint. They have not filed any responsive plea or otherwise defendant in the matters. This is simply a matter on the petitions for entry of the default judgment. Your appearance, Madam Counsel, on behalf of Capital One Bank, please.
Jennifer Dillo, P69855, appearing on behalf of the plaintiff.
All right, and that's with regard to each of these matters. Is that correct, Counsel?
That is correct, Your Honor.
All right, I'm now looking for, in the suffix 845, Keith Brooks Jr., person living on Maxwell Street in Detroit. If you are on this Zoom, please say something at this time. That matter was set for 9:30 a.m. It's now 10:12. The court is also looking at this time on the suffix 859 for Lanata Whitlock living on East Grand Boulevard Street in the city of Detroit. If you are on this Zoom, please say something at this time. That matter was set for 9:45 a.m. It is now 10:13. The court is also looking for, under the suffix 747, Ronnie E. Foster, living on an address on Brighard Street in the city of Detroit. If you're on the Zoom, Mr. Foster, please say something at this time. The court is looking for, and I should indicate in that matter, the matter is set on for 10 o'clock a.m. It is now 10:13 a.m. Regarding the suffix 843, Capital One Bank versus Nicole Anderson, I'm looking for Miss Anderson on Van Dyke Street in the city of Detroit. Miss Anderson, if you are on this Zoom, please say something at this time. This matter was set on for 10:15. The court will hold it in abeyance in anticipation of defendants appearing at that time. Counsel, it looks like at least in the other three matters, defendants did not appear and have not, again, as indicated previously, respond to respective complaints. Accordingly, the court will now enter the judgment by the default with regard to those three matters. In regard to the suffix 845, the judgment will now enter for $1,241. I do have the judgment form. That document is being signed at this time. The court is also looking at 859. In that matter, the court will enter the judgment where the defendant has not appeared at this hearing for the total sum of $2,325.07. The court is signing the order at this time regarding that matter. The court is addressing now 747. The defendant has not appeared regarding this matter. The court will enter the judgment as trade. The total sum on entry is $2,001.38. The court is signing the order at this time. Regarding the application in the final matter, it is 10:15 at this time. I am going to wait. I'm going to wait 5 minutes or so to see if the defendant will show up on that matter. If the defendant does not appear, the judgment will enter per course. And I should indicate the judgment amount with regard to the suffix 843 is $1,404.12. If Mr. Cole Anderson does not appear, she's not appeared up to this time. She does not appear. The court will sign that order. All right, Mr. Johnson, what's the last four digits on the case that you have, sir?
1800.
This is case number 21-16-1800. This is Security Credit Services LLC versus James Henderson. The matter is before the court on an application for entry of default judgment. The record should reflect that the default of the defendant was previously entered by this court where the defendant failed to respond to the complaint or to otherwise plead regarding this matter. The court did set the matter on for hearing with regard to the entry of the actual judgment itself. Counsel, your appearance in this regard, sir.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Thank you, counsel. I'm now looking for James Henderson or anybody representing Mr. Henderson. If you are on this Zoom, a person reportedly living on Piper Street in the city of Detroit. If you're on this Zoom at this time, please say something. The record should reflect that this matter was set on for hearing at 10:05 this morning. It is now 10:17. The defendant has not appeared regarding this matter. Accordingly, the judgment will enter by default on the terms as prayed. The court will enter the judgment for $2,729.94. It is so ordered, and I've signed the order at this time.
Thank you, Your Honor.
This is case number 21-166317. This is Genesis Credit Union versus Frederick William Brown. The matter is before the court, set on for a hearing on this matter. I do see a document contained within the court's file, which is a stipulated order for additional dismissal. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Weston on behalf of Genesis P number 80307.
Thank you, Mr. Neal, and good morning to you, sir. What's going on here? I do see the stipulated order for conditional dismissal. Should I be signing that?
Yes, Your Honor. We had submitted the conditional dismissal to the court for signature and removal of the court's docket. We weren't able to get an update to understand if the court was taking this under review or not, but parties have no objection that I'm aware of to the court's entering it and having the case disposed of.
Well, I'll tell you that I signed this order some time ago. That's November. But I have no idea why it's still in the file and did not get processed. There's a likelihood that I never removed it out of the file and handed it over to the clerk. But I'm doing that today. So the order is signed, and we'll get copies of that out right away.
I appreciate it, Your Honor. Have a good day. Thank you.
I'd like the record reflect that it's now 10:20. The matter involving 843. I'm looking for Nicole Anderson or anybody representing Ms. Anderson. Ms. Anderson. Court has made multiple calls for defendant this morning. She has not appeared. Accordingly, the judgment, as previously set forth on this record, will be entered by default. I'm signing the order at this time. Good day to you, still.
Thank you. Have a good day.
Mr. Rosen, give me the last digit on a case or cases that you have. How many do you have in front of you, sir?
Yes, I have two, Judge. One's on your 1015 docket, one is on your 1020 docket.
Got it. This is case number 21-164462. This is Credit Corp versus Jasmine Smith. Matters before the court on an application for entry of default judgment. The record should reflect that the court has already entered default regarding that matter where defendant did not appear or plead in that matter. Counsel, and I will also call it this time 21-162318. Credit Acceptance Corporation versus Anthony Liggett. And the matters before the court on the application for entry of default judgment. The record should reflect in that matter that default has already been entered. The court set up hearing on this date regarding entry of the proposed judgment regarding this matter. Your appearance regarding these matters as plaintiff, please, sir.
Judge, may it please the court, I'm the attorney of record. My name is Attorney Richard Rusin. For the record, my bar number is 35222.
All right, thank you. Good morning to you, Mr. Wilson. I'm looking first of all for Jasmine Smith. Jasmine Smith, a person living on Fielding Street in the city of Detroit. If you are on the Zoom, please say something at this time, Ms. Smith. It appearing now that Ms. Smith, whose case was set for 10:15, is now 10:22, has not otherwise pleaded in this matter. It appears that she's now not appeared for the hearing regarding entry of the judgment. The court will accordingly enter the judgment now by default on the terms as prayed. The judgment will enter now for the total sum of $11,906.88. Is so ordered at this time.
Thank you, Judge.
Now for Mr. Anthony Liggett regarding the suffix 313. Say something if you're on the Zoom, Mr. Liggett.
Judge, may it please the court, I am the attorney of record, Richard Rusin. My bar number is 35222. I appear for the plaintiff today.
Yeah, you had your appearance on the matters when I called him previously. Mr. Liggett, say something so I can hear you, sir.
Good morning, Your Honor.
Good morning to you, sir. Good morning. Welcome to this hearing. This is a hearing for a petition for entry of a default judgment. I don't have any response that you made throughout this case, and that resulted in being put in default regarding this matter. The plaintiff today is requesting that the court enter the judgment now. That judgment is would be in the sum of $14,484.76. So tell me anything that you want to tell me about that. Go ahead, Mr. Lake. What do you have to say about that, sir?
Yes. Well, I had that vehicle and I was paying the note on that vehicle and everything. What happened with that vehicle, it was a Impala. It was a Chevy Impala. I was at work one day in what was it? A Jeep Wrangler on the side of my car at work. Sam's Club, it had actually caught on fire. It had a defect in it or something like that in the parking lot, to the point that it was on fire and my car was next to it. That's why the car pretty much got taken or shipped to a yard and everything. And I started making payments on the car and everything. And the car was completely gone. There was nothing I can really do with the car. It was totally damaged. Everything.
Did you have some type of insurance, or did you seek any type of recovery for the damage that was caused by someone else to the vehicle?
I had no fault on it, and then the day the car caught on fire, I had the craziest day of my life. I had actually got put in jail that day for like some warrants or anything, so I never had the chance to have anybody go for like damages or anything of the car. I did reach the fire department and they gave me like this was probably like 2-3 years ago. They gave me a copy of the incident and everything, but I was never ever able to reach the guy or the guy insurance to seek out anything because I had to go to jail for I did like 7 months in county around that time.
Yeah, sometimes when it rains it pours, that's crazy.
Yeah,
Well,
that was a tough year.
So this is of course, the contract that you signed obligated you to pay for the vehicle. So you still, unless there was some type of insurance to pay it off or whatever, you still end up being obligated under that contract when you don't have a car. What did you have any thoughts about what you want to do with it? Did you want to try and talk to the other side regarding payment arrangements or any effort to try to get this resolved? What do you think you'd like to do in this regard?
probably talk, we can talk about it, get it resolved and everything. If they would come down, I don't have like I'm not even working right now and everything. So I'm on unemployment and stuff. So we can talk about getting it resolved. If they want to come, we can do that. That'll work.
All right, so what's the challenge here, of course, is that because you didn't file an answer to the complaint back when this was filed, is it already puts you in default. But I believe that Mr. Rosen will speak with you in terms of ways that you might get this.
Yeah, I think a breakout room may be appropriate, Judge.
Yeah, so I'm gonna send you to speak with Mr. Rosen. He represents the other side on this. And if the two of you talk, maybe you can find a way to reach a resolution of this. And I'll be here when you come back to talk through this and see if you're able to do so.
All right, thank you, Judge.
Yes, sir. I'm gonna send you a notification right now, Mr. Liggett, to go to breakout room number 1. As soon as you see that, just click in, sir. And Mr. Rosen, I'm sending the same to you, sir. This is case number 21-162213. This is Bank of America versus Sean Lee. The matters before the court on application for entry of default judgment. The record reflects that the defendant is in default and has not responded to the complaint in this matter. This matter set on at 10:10 this morning. Defendant has not appeared. No one has appeared for the claim from the plaintiff's office, but they have filed their application for entry of default. The court will enter the default at this time where the defendant has not appeared. Again, I'm looking for Sean Lee. Sean Lee, defendant has not appeared. Judgment will enter for the total sum of $14,442.92. They so ordered at this time. The court is calling for 21-163452. This is Capital One versus Ishmael Diaz. Matters before the court on the application for entry of default judgment. Defendant has not responded to the complaint or otherwise defendant in this matter. The court said that in the default of the defendant has entered. The court sent the matter on for hearing on today's date regarding the show cause for whether or not the judgment should actually be entered at this time. It appears that defendant Ishmael Diaz has not appeared in this matter, and accordingly, the court will enter the judgment by default once again. Ishmael Diaz, dare say something. The judgment will be entered for the total sum of $2,494.45. So ordered at this time. Court is addressing case number 21-158-345. This is Capital One Bank versus Takina, Washington. The record should reflect that the matter is before the court on the filing of an application for entry of default judgment. The record should reflect that the defendant has not responded to this matter, has not filed any response to pleading, has not otherwise defended in this case. The default of the defendant was previously entered by this court. Today, there is an application for entry of judgment based upon that default. I'm looking now for Takina, Washington. Takina, Washington, if you're on this Zoom, please say something at this time. It is 10. This matter is set for 10:25, strike at 9:25 this morning. It appears that the defendant has not appeared. Accordingly, the judgment will enter by default for the total sum of $6,149.99. So ordered. The court is calling got a couple other matters that I'll be calling in just a moment. One of them involves Capital One versus Charles Howard. The other one involves U.S. Bank, TD Bank USA versus Anthony Starks. I'll be calling those matters momentarily. All right, we're back on record regarding 3218, that's credit acceptance versus Anthony Pickett. Mr. Rusin, if you'll update me regarding this matter, sir.
Yes, thank you, Judge. I'm assuming that Mr. Leggett is back here on the record after leaving the breakout room. And I can tell you, Judge, that I proposed a small dollar amount, which would not even make the judgment interest at 13%, but taking into account Mr. Leggett's circumstances that he described on the record. Unfortunately, I'm of the opinion at the moment that there is no settlement I can put on the record, so I will leave it to you as the trier of fact where we go from here.
All right. So, Mr. Liggett, anything you want to say to me, sir?
Yeah, I'm just looking for employment right now. Right now, I'm like, I don't really have employment right now, so I just need some time to kind of figure this thing out. Like, it was just kind of unfortunate situation with the car, but I kind of need some more time. I don't have any money to like kind of keep up with the payments right now and everything we talked about.
All right, under all the circumstances, the only alternative that the court is left with is the following the rule that allows for the entry of the judgment. You have the right upon entry of the judgment to file a application with the court for partial payments, and to put in your application the reasons that you believe that you should be able to make the payments by partial payments. And the court will review that if you submit such an application. Also, as circumstances become better for you, you always have the alternative of contacting Mr. Rusin's office to talk about ways in which you might be able to attack this without it becoming a wage garnishment type of situation once you are able to obtain gain for it. At this time, the court grants the application entry of the default judgment. The judgment will now enter for $14,484.76. I'm signing an order in that regard. And I do wish both sides well. I wish you the best in your endeavor to gain employment, sir.
Thank you, Your Honor.
And Mr. Liggett, you'll get a copy of that document also.
Okay, Your Honor.
This is case number 21-160844. This is Capital One Bank versus Charles Howard. Matter is before the court regarding the application for entry of default judgment. The record should reflect that the defendant has not responded in this matter. Otherwise, the defendant, accordingly, the default has previously been entered in this matter. Today, the plaintiff has requested entry of judgment on that default. I'm looking now for Mr. Charles Howard, living on Field Street. Mr. Charles Howard. It appearing that defendant has not responded to the court's call, has not appeared on today's date. The matter is set for 10:30. It is now 10:36. The court will enter the judgment by default at this time. The total amount is $1,431.98. Madam Recorder, the final matter on this call is set for 10:40. I'll be calling that short.
Okay. Well, that snow ain't no joke. Whew.
Yeah, it looks like it's trying to come on down, huh?
Yes, it is.
So you know that they canceled my kids' school for the rest of the week
Oh, they did?
yesterday, yeah. Upon hearing the weather reports,
Mm-hmm.
they just went back on Monday. And upon hearing the weather report, they vacation.
I thought they said they were gonna put them on Zoom.
They said they're gonna use their snow days that they have.
Oh. Okay. Oh. They certainly had one today.
I remember a while, you're my age, Steve, young chick. But you remember, you couldn't get a day out of school.
Right. No days.
Begging for a snow day, please come now. Yeah,
So we on YouTube now.
I think we'll be, oh,
I know, I'm still, that's what I was talking about that, but still, that's okay for you too.
I hope we get
Oh,
like, I
okay.
hope we don't get as many inches as they say we will.
You say you hope